take something from.
I think the majority of attorneys will listen, but strongly recommend that the client listen to the attorney.
All right, back to the courtroom right now.
The sidebar, the bridge counsel, one way or the other. You just have to be present because what takes place when they're going through the process, because there's so many people, they can look around and make sure the numbers are consistent and everything with their notes. So it's not a problem. Just wait on the go. As I say, I commend the lawyers. They're doing a great job. I mean, I've been here doing this a lot more days than this, so this is good. Today's only Thursday, and this is wonderful. We're at this point. Yes, sir.
Yeah, may I
No, come on, Lord. No, come on, Lord. We're here. Come on, Lord, please.
Our 11 Alive coverage of the Sneiderman trial continues. Again, we have the attorneys back in front of Judge Adams, and this has been very different today. This has been a lot of the sort of small parleys, there seems to be more intrigue today. It's been more difficult for us to follow as viewers of this than over the course of the last few days, where you've had a lot of dialogue between prospective jurors, the judge, the attorneys. There has been a sort of banter, a public banter that has gone on and on. Today, not so much that. There has been sort of a go and then stop, go and stop, and then a lot of it has been this sort of private discussions in front of the judge.
I think a lot of it, number one, if you look to your left, you're going to see that the jury is still there. If they're talking about any technical issues or the proper procedure to choose a jury, you don't want the jury to hear that. You want them to be pure. You don't want them to be affected by whatever the attorneys are saying there. So this is normal. The bench conference is normal. Normally the judge will have a little button where he can put static up so you can't hear it. So this is all normal. But you're getting very close to when they are going to have the jury selected. And this is the last minute. Make sure you have your alternates, where you're going to choose them from. If you have any strikes or have any objections at this point, let us know. And so now they're going to go back. I think they're going to pick a jury.
You do? You think they're going to be all set here very shortly?
I do.
Okay. Back to the courtroom.
Oh, I mentioned, ladies and gentlemen, because I know sometimes, especially if you're sitting on the wooden benches, that wood becomes firm after a while. So if you want to stand, I can't let you leave right now, but if you want to stand where you are and just stand and stretch, it's okay. You can do that. And also, if it gets to the point somebody needs a restroom break, which is okay, just raise your hand, let me know. And if one person needs one, everybody gets one. I'm not going to force it on you, but because like I said, I was just talking while they were making their selection, which is not a problem. Because everybody, this is my term, is on a different schedule, which is okay. But I know the individuals who are seated to, this is you, my right, your left on that side, those seats are a lot more comfortable because we have padding there, and they may or may not recline. I think I never sat in them, but I'm assuming they recline a little bit. Right, like I said, I never had the opportunity to do that, so I'm just assuming they are soft and comfortable. They look soft and comfortable for here. And therefore those individuals who are seated to my right have a little bit more comfortable of a seat. But for right now, you just have to be with me. There you go, see, Sixth State is taking advantage of what I just said. If you need to stand and stretch, it is wonderful. It is not, I just can't let you leave the room right now. However, if and when someone gets my attention indicated that they need a, you can do it like this way, break, and that means, which is okay. And I'll take responsibility for taking a break, and I'll give you an opportunity to go out collectively. Because right now, we're gonna have to keep everybody together just for lack of a better term, management of people. So I know you're all individual thinkers, and normally you can do things on your own, but right now, we gotta do it as a group, just for right now. And I appreciate your patience, your understanding, not drawing any emphasis from that one way or the other.
Yeah, if I could just bring to the court's attention, we need not address any more of the matter that we brought to the court's attention a few minutes ago. We're satisfied with the cigarettes.
Okay, that's fine. Thank you very much, Mr. Speaker. But as I said, ladies and gentlemen, feel free, stand, stretch, if you need to, is where you are. I just can't let you go right now. It's just that when the building was designed, and I know sometimes cloth and padding is put on benches, but in order for, this is my term, to save a little money, there was no cloth or padding put on the benches. Because I know you can go different places, churches, synagogues, funeral homes, and the benches have padding. But here, we decided not to, and just to save money. But as a result, as time goes on, the wood does not give way. And as a result, it's firm, and it gets firmer as time goes on. So, but that's just the way we are constructed right now. And for whatever reason, it's getting a little warm in here. I didn't turn the air conditioner off, but that happens sometimes. This building, it breaks. But we will make a request at the appropriate time to have the air conditioner on. But it happens. We're still inside. You good now? That's fine. No, we're good. No, that's fine. No, you can stay. Yeah, you can't talk. You can't really talk. Like, you can stand and stretch, but don't. No, you can stand. If you want to stand and stretch, that's fine. It's just that we can't have, we're not having group discussion right now. And I know, I tried it for a minute. I just stopped talking to see what your reaction was going to be. And you started moving on, which is okay. I have no problem with talking and filling in this time. Matter of fact, if need be, I'll talk for another 3 hours. But no, I just use that as a time of estimate. It's just that I was always thought I had to, and I don't mind talking, and I don't mind actually hearing my own voice. So it is okay. But I was just using that to pass the time. So because when it gets quiet, it's just quiet. You can hear a pin drop, and with that, it seems as if time is running a lot longer or slower than what it is. But actually, time runs at the same time, whether I'm talking or not. We will, because it does sound like it's getting a little warmer. The air's not circulating as much as it should. But I appreciate your patience, your understanding. But this side of the process works all the time. Jurors come in, they sit, lawyers look at the list back and forth, but they are doing a wonderful job because, as I said, I thought I wouldn't get to this point until tomorrow. So as I said, we are a day ahead of schedule. So this is wonderful. It's almost, I almost use the term of blessing, but I don't know if I can use that term. It's very good, very good. Because today is Thursday, and it's early. So it is not, and everything is relative, and I fully understand that. And as I indicated earlier, after the jury has been selected and those individuals will be given certain instructions, and the ones who are not selected will be released. We're not there yet, but we will be there fairly soon. And actually, it will, for the lack of a better, complete your service. And as you know, here in DeKalb County, we have over 700,000 residents. And the way the system works on the jury side is 1 day of service or one trial. And this is considered one trial. So for the purpose of that, it's 1 day. So in the scheme of things, we're still contained within that same period of time. But I actually worked out well. And I do. Thank you very much for your patience. Thank you for your understanding. Thank you for your willingness to participate in the court processes. Because without you, the courts actually could not operate, whether it's a civil or criminal matter.
Welcome back to 11 Alive's coverage. I'm Jeff Hudlinger along with attorney Bill McKinney. And Bill, I was reading one of Julie Wolf's tweets from inside the courtroom. 5 jurors now asleep, which maybe is a commentary on how things have been moving along at a snail's pace this afternoon. We started at 1:30. We've had a couple of breaks, but for the most part, an hour and a half into it, and nothing really has been decided as of yet, or so it would seem.
It appears to me they're still going back and forth with their selection or exclusion of those people they want to strike from the jury. That's what's going on now. The lady in purple is the clerk. She's waiting for them to finally finalize the alternates. That's the last step in the process. And then they're either going to do a silent strike and just announce their jury, or they're going to go back and forth as each juror stands up, and they will say either they accept them or they're respectfully excused. So we're just going to have to see what the judge does at this point.
The judge has been talking almost nonstop to the jurors as this sort of bantering has been going back and forth, everything from talking about coffee to serving animal crackers to put away your newspapers, don't consume anything. Fire marshals have come in to make sure that there are not too many people in the courtroom. A-OK is the word from them on that front, but it has been sort of a courtroom of intrigue in that both sides have been busily working and the judge has been working in a different way.
You know, the judge wants to be out while this jury selection is taking place. He didn't go back into chambers. It's commendable. Some judges will, and then once it's all done, they'll have the judge come back out. He stayed. But I think what he did is he's just explaining what the jury's responsibilities are. He took the time to do that while these attorneys were picking the jury. I think that's what he was doing. and he did it well.
Is there any scenario where a jury is not picked today? I mean, do you see any way that maybe this is not accomplished and it has to be carried into Friday?
I don't see it unless there's what's called a Batson challenge, and that is if one side or the other feels that the strikes are racially biased in one way, they will hold the jury, and then they will require the attorney to establish a sufficiently neutral reason why he struck certain jurors. I don't see that happening, but that's always a possibility.
The issue of race has come up in the form of the Sneiderman Trayvon Martin trial, but I think it has been more of a kind of roundabout way, talking about the system isn't perfect and that sometimes justice can slip through. That has come from some African American jurors who felt that there was unfairness and bias there that has sort of resonated in this courtroom and from all probably practical applications all across America. It's been in a lot of courtrooms this week as a subject of discussion between attorneys, judges, and jurors. But as far as an issue of race in terms of selecting a jury at this point, that seemingly would not be part of this mix.
It should not be at all, because obviously we have a Caucasian defendant. The person who was killed obviously was Caucasian, so it should not come up. But Batson can also be used not only for race; it can be used for if you exclude all the women. If you target a significant member of the panel based on race, that's improper, or sexual orientation.
All right, here we go again, once again in front of Judge Adams, the defense making their way in front of him, and here comes the district attorney and his team as well.
You know, what sometimes happens is that during the selection process, sometimes the defendant or prosecutor is going to believe that the judge excluded somebody. So your group of the finalists of the jury panel may not match what your opposing counsel has. So you want to get together with the judge to make sure you're working with the same prospective jurors to exclude. Otherwise, you make an error, and you may think someone has been excluded, and they haven't been. So a lot of this, I think, is verifying not only the process, but that we have the same group of jurors we're selecting from. We have the same alternates we have to choose from. And that, unless there's some objection now as to maybe someone forgot to bring a motion for excluding a juror for cause, that would be the only thing I can see that's going on at this point.
So while both sides have been going back and forth on trying to select a jury, and the judge has been involved with the prospective jurors, sort of giving them instructions, large and small, the judge then jumps into the middle right now to try and be an arbiter between the two sides. Is that what the role that he is playing right now?
It's not so much as an arbiter, but basically letting both sides know who the jury panel is, who your alternates will be in terms of selection process, and to go forward.
All right, back into the courtroom now.
Completing the process, completing the questionnaire. I was just looking back over, it was about 20 plus pages, and that was a lot of information for the lawyers to digest over this period of time. Again, I do want to thank lawyers for moving through this process in a very, as far as I'm concerned, expeditious way. The next phase of the process, I will tell the clerk to identify those individuals by numbers, and she will give you certain instructions and follow those instructions, and I will give you additional information and instructions at the conclusion of hearing from Jay. All right? You may proceed, Jay, with jury management.
For those of you seated in the box, when I call your number, if you would, remain seated. If I do not call your number, please stand in the back of the courtroom.
And you will only be standing until we can get seats in the gallery. But Mr. Deputy, the doors are open. Anybody can come in and out, but the doors are open, courtroom's open. You may continue.
Juror number 5, juror number 14, juror number 17, and juror number 28. Those jurors, please remain seated. The others that I did not call, if you would stand in the back of the courtroom.
So remaining should be 5, 14, 17, and 28. And ladies and gentlemen, stand at the back because I don't have seats right now. You cannot leave right now, they just stand. And when seats become available, you may be seated at that point in time.
For the rest of you, when I call your number, please come up and have a seat in the jury box. Juror number 29, juror number...
Wait 1 second, come on up, because Come on, 29. I just want to make sure we're moving in order.
Juror number 31.
Come on up, 31. Please.
Juror number 33.
Come on up. Thank you. And thank you for your patience.
Juror number 36.
Thank you. Come on up.
Juror number 38.
1 second, let me make sure you come. Come on up. Thank you.
38.
38.
Juror number 50.
50. You can sit in any order. Just come on in and have a seat in the jury box.
Juror number 52.
52. Come on up.
Juror number 57.
Thank you. Come on up. Thank you for your patience. Thank you for your understanding.
Juror number 61.
Thank you. Thank you for your patience. Come on up.
Juror number 66.
Come on up.
And juror number 72.
And those remaining jurors, you can just have a seat in those vacant seats for right now. Just got a few more things. Thank you for your patience, everyone. There should be enough seats for everyone. And if you could still have those numbers very visible, because I'm gonna have the lawyers make sure that the individual, just stay on if you don't mind. Lawyers, if you can look in the jury box and make sure, I can't see your number, young lady. It's just that we're tracking by numbers. I know your name, but lawyers, if you could, look in the jury box and make sure those individuals who are currently seated in the jury box are consistent with your notes and your decision. Okay, from your state?
Yes, sir.
From the defense?
Yes, sir.
All right. All right, ladies and gentlemen, in the jury box, you're the ones who have actually been selected as the jury at this point in time. I know you've been sitting for some time, so I'm gonna let you take a brief break in the jury room where there's restrooms, and I will bring you back out and give you some additional instructions, okay? You can go ahead and remove those numbers as you go through. The deputy's gonna show you where, and Jay will show you where the restrooms are. But you're on the jury, when you follow the instructions with Jay, please, and I'll give you some additional instructions. Also, go ahead and give the deputy your cell phone. You might get used to that process, because you can't have cell phones, laptops, iPads, any type of communication device here in the jury room. So, go ahead and follow Jay at this point in time. Go into the jury room, you turn out the numbers. You have the deputy, cell phones, iPads, any type of device that you have for communication, put it in the off position. It's going to be returned to you, but we're still going to do it every day. Cell phone, and if you could put them in the off position, iPad, any type of communication device. And there is men and ladies restrooms there available. There's water in there. There will be water in there right now. But there's a few more things we're going to do together. Thank you very much for your patience and your understanding. All right, lawyers, may be seated momentarily. Jay, no, that has to stay there. All right, ladies and gentlemen, those are the individuals who are remaining. You can go ahead and remove your numbers and your blue identification card. This will conclude your service on this term with the jury set. And I'm going to ask Jay to come and collect those badges from you at this point in time. And again, on behalf of the Superior Court, thank you very much for your patience. Thank you for your understanding. Have a wonderful day. Enjoy the ride home. Bye. Lawyers, what we're going to do, and I know we have to go to the court on the record before we conclude, we're going to take a 5-minute break. Is 5 minutes enough, lawyers?
Yes, sir.
For us to go back on the record?
Yes, sir.
And then we'll go back on the record and conclude for today. Where's my deputy? It'll be 5 minutes. All rise.
signal over here. All right, welcome back to 11 Alive's coverage of the Sneiderman trial. I'm Jeff Hullinger along with attorney Bill McKenney, and we are taking a look at some of the news. If you are scoring at home, we have the jury numbers that have been selected, that we now have a jury. And according to Julie Wolf, who is tweeting from its courtroom, none of the sleeping jurors, and we counted 5 of them, have made the cut. So here we are taking a 5-minute break, Bill, and will we conclude now when Judge Adams comes back?
This is totally discretionary. Now, normally, the judge can do one or two things. Obviously, he's going to swear the jury in if he hasn't done that already. They're going to all take an oath. And then the opening statements normally will be made, starting with the prosecution. Now, it is about 10 after 3, and it's up to the judge. He can either confer with counsel and say, would you like to start your opening statements now? Do you want to prepare, and we'll start in the morning at 9 a.m.? And he'll get a feedback probably from the prosecution and from defense what they want to do. I don't know if Judge Adams wants to push this through kind of quick. He could certainly start with the prosecution opening statement. The prosecution normally does not like the defense to have the night to prepare their opening in response to the opening prosecution. So I would suspect that the prosecution is going to say, Judge, if you want us to go forward, we kind of object. We'd rather wait until tomorrow if we can do it together. So you have the opening by prosecution and then the opening by defense.
Now, Judge Adams has talked about tomorrow being a day, an off day or a dark day, if you will. Are we talking about Monday everything would begin, or do you see a scenario where maybe he goes against that and decides that Friday is the day to begin?
You know, he could change his mind on it. He may want to just give a rest for the attorneys involved, and also maybe possibly for the new jurors that we now are going to be sworn in. It's totally up to him. But I can tell you that if he wants to move it, he can have them start their openings today. But I think the prosecution is going to object to personally, because they're going to say, wait a minute, we give our opening, and then the whole entire night, defense has an opportunity to kind of react to it. They'd rather have the reaction done very quickly. They sit down and the defense goes forward. That way they don't have time to prepare.
What are you most interested to see in terms of the jury composition? Do we look for age? Do we look for gender? How should we look at this breakdown?
I would look first at the issue of gender. I'd like to know how many females are on there, and the age, and whether we know whether they have any children. Because this entire episode occurred at a daycare center. That's where this man was murdered. Bullets were flying. There's children there. He was just dropping his children off. And that's going to have an impact, I think, on anyone who has children.
You've gone to that point over and over today, which is interesting. I think in the last couple of days, we probably have talked more about the issue of infidelity and whether you have been impacted, the questions to the juror, whether you have been impacted by infidelity in your own marriage. You are illustrating something different about having children and the issue of the daycare itself. I think it's an interesting turn and a twist that we really haven't bantered about much.
Well, you know, if the prosecution is correct, and this was some conspiracy where Ms. Sneiderman realized that her husband's going to be killed, why would you do it in a daycare in front of his child where there's other children that are exposed to the shots, to the bullets? And again, I don't know, they're going to obviously prove motive, but to me, that is even worse than infidelity. I mean, if you can compare the two, of risking people, little children, being killed out there. And I think that's something that, if I was prosecuting a case, I would bring forward.
How much of the issue will be Andrea Sneiderman herself, as far as the prosecution trying to play this theme of her being unlikable, the sort of dynamic of her behavior, and certainly we haven't seen it this week, but how much of the issue just becomes her as a person?
I would say probably 50%. I would probably say that what they want to do is show her, and obviously they're going to have videotapes, they're going to have her testimony, sworn testimony, being contrary to what witnesses say. And I think they're going to show her demeanor, because that impacts on her credibility. And this issue, this entire, at least 13 counts, deal with her credibility. What she knew and when she knew it, and did she cover it up? Did she make false statements? And was there some type of underlying conspiracy?
And then the defense, conversely, will try and paint her in a much different way, that she is misunderstood and has been the victim of a stalker who then took it to the extreme.
Right. She had, and one of the grounds here, she didn't have reasonable grounds to believe that her boss was the shooter. And her reaction was she was confused at the hospital. She didn't realize whether he was shot. The witnesses are mistaken. She never said that because her testimony, she did not know why she was going to the hospital. Didn't know that her husband was shot. And so I think there's going to be some issues of how did she find out all these intricate details if she had not spoken to anyone and all she did was respond to the hospital.
One of the interesting aspects of this entire week of trying to find a jury and seat a jury in this trial has been how many of the jurors knew not only the victim but the assailant by name, which doesn't happen in many cases. You just don't see a lot of cases like that.
No, you don't. I mean, this is a high-profile case. That's why I was surprised about the non-sequestration. Whether it's a murder case or, in this case, 13 counts that could put her behind bars for 30 or more years, you don't want the media coverage to infect or taint your jury panel. You want them to only hear the evidence in this courtroom. And I think the judge runs a risk of letting them go. I really do.
Why do you think they were not sequestered?
This is just a guess, is possibly because the murder charge was taken off the table. And now we're down to basically lying, false statements, and hindering prosecution, obstruction, things of that nature, which maybe to the judge in his mind is not as serious as a murder, but it's still an issue of whether it's going to taint the jury.
Trying to get a jury to stop from consuming mass information, whether it's television or radio or just any way. I mean, there's so many ways with our iPhones and our iPads to get information these days. Sequester seemingly would be about the only way to try to ensure that you've got an information lockdown, at least during the course of the 3 weeks of the trial.
The most difficult part is when that husband or wife goes home, sitting across the dinner table, and says, "Hey, what happened today?" "I can't tell you." They say, what is that? Happy wife, happy life. There's going to be some communication there. The wife or the husband is going to try to pull out what's going on. What happened today? I read in the paper. Or a neighbor may call, or the paper may arrive. Something may be on the news, or driving with your car. You may hear it on the radio.
How about the political ramifications of this? And I know you're not here to talk about politics, but certainly when you're talking about high-profile cases and you're talking about an elected position like the district attorney of DeKalb County, the political ramifications are great in the perception of whether you're doing a good job or you're doing the right job or what happens at the end of this trial when the verdict comes in. There is going to be that repercussion in this community.
There will be, but I'll tell you, by he being the district attorney, taking the step of removing the murder charge and saying that ethically he could not prosecute it, I think it's a win-win for him. Because number one, he's taken away the murder charge because ethically he couldn't prove it, and he's gone with those charges he thinks are fair. And all he needs is 1 out of 13, and it's a winner for him. If it's a complete wash and she's found not guilty, yeah, I think it may have significance because he basically indicted her on numerous serious charges, including felony murder, and basically ruined her name, with those charges. And if he can't prove them, there's going to be a problem, I think.
All right, here comes Judge Adams, and we go back into the courtroom.
Momentarily, before we go back on the record, just very briefly, thank you very much. All right, Kelly, we're back on the record. Are there any other motions at this point in time before I bring the jury out and give them their instructions so they can go home for the weekend, Mr. DA?
Nothing from the state, Your Honor.
From the defense?
Your Honor, there is one motion from my approach, just to, I don't think I made a court copy, and just to present to the court just a motion that I filed earlier today that does not need resolution today, does not need the court's intervention today. Basically, it is a motion asking this court to exercise its discretion under, what, 24-6-615, I think is the new number, the rule of sequestration to allow any expert witnesses for either side to be allowed to be in the courtroom during the testimony of experts for the other side. There is authority that allows that, it's within your discretion. I have just served the state with that today. It will not require extensive argument. I've asked the court just to consider it, let me know whether or not that's something we can consent to. If not, it would require, as I said, no more than 5 minutes argument.
And Mr. Petrie, I would confer with Ms. Patterson this morning. And this was filed today?
Yes, sir.
And the clerk's office has been filed downstairs?
Yeah, that should be a stamped copy.
Yeah. And the district attorney will serve with this. It looks like it was stamped at 1:23 p.m.
Yes, sir.
And Mr. James, have you or one of your assistants received a copy?
Your Honor, we just recently received a copy. Yes, sir.
And what is the state's position? I know you just received it less than 2 hours ago, but what is your position, sir?
Objection.
All right. Lawyers, since there is a noted objection, what I will do prior to hearing additional arguments, since they just got served, that's 2 hours, obviously all the lawyers have been involved with the jury selection. I will take this matter up on Monday morning, and the lawyer represents, you can argue as long as you need to, and I will give you a ruling prior to opening statement.
Okay. Your Honor, just as a matter of housekeeping, I do not believe that we need a ruling before opening statements. It's just a matter of who gets to sit in the courtroom. I'm happy to do it, argue whenever you want us to, but there's no reason to delay opening statements because of this.
Oh, in that case, I have no problems if we can do it right before, right after one of the breaks. Because you're saying, if I understand what you're saying, anytime an expert for either side is testifying, that person who wants to, I know they're opposing it, would like to be present to hear that expert testimony.
That's right.
And I was gonna ask the state when did they anticipate calling the first expert, but I can take it up. Mr. James, can I take it up later on Monday, or do I need to take it up early on Monday?
You can take it up later on Monday.
Okay,
Your Honor.
let's just plan on, obviously prior to any expert testifying, that this be done, late on Monday. So my plan will be, as, you know, we will bring them in on Monday, opening statements, and we'll go forward with presentation of evidence. Once we conclude for Monday evening, I don't know what time right now, we will deal with this matter at that point in time.
Yes, sir.
Okay? And let me locate my staff attorney, just so she can start working on this issue. Also, hold on 1 second. I'm gonna introduce Counsel, Mr. James. Yes, Mr. James, you're up. Yes, sir.
Just clarity's sake, Your Honor, my understanding of Your Honor's ruling or Your Honor's position is that their expert would not be allowed into the courtroom until Your Honor ruled, and that includes opening statement as well. That the rule of sequestration would be in effect until Your Honor ruled and allowed that said witness in the courtroom.
Yes, Mr. Petrie?
I understand.
Okay.
Yeah, I just wanted to make sure I was clear, that's all.
Yes. I mean, yes, until I have actually ruled on the motion that was filed at 1:23 p.m. on August the 1st, yes. That's, neither side will be allowed to violate the rule or have any sequestered witness to be present. Obviously, there are other exceptions, but we'll do that on a case-by-case basis.
Yes, sir.
And as it stands right now, without anyone, I don't need anyone to reveal to me any particular trial strategy, this will be taken up at the conclusion, or near the conclusion on Monday evening. All right?
Yes, sir.
And estimation on time, and actually we'll be doing some research over the next 4 days also, will be less than 15 minutes.
Yes, sir.
All right, and this is this legal argument, which is fine. Any other matters?
Nothing from the state, Your Honor.
No, sir.
defense?
No, sir.
All right. Mr. Deputy, bring in the jury, please.
All right, welcome back to 11 Alive's coverage of the Sneiderman trial. Bill McKinney is our attorney, our analyst this afternoon. We are grateful for having him here with us, sharing his years of experience. And a jury is all set and ready to go. Monday is fast approaching for the beginning of this trial.
It is, and we're not sure, you may, Jeff, whether he's going to allow opening statements or they're going to reserve those until Monday morning.
To the floor, but you can move the podium wherever you wish. I'll complete that in a minute. Come on in, ladies and gentlemen, make yourself comfortable. Come on in, ladies and gentlemen, make yourself comfortable. Come on in, ladies and gentlemen, make yourself comfortable. Come on in, ladies and gentlemen, make yourself comfortable. Come on in, ladies and gentlemen, make yourself comfortable. Come on in, you can sit in any seat. Technically, there are no assigned seats, but you can sit in any seat as long as everyone has a seat. Come on in, ladies and gentlemen, make yourself comfortable. I always tell ladies and gentlemen, if you like sitting on this end, come out first. If you like sitting on that end, come out last. That way everybody doesn't have to fall over you. Because during the break, you may be seated lawyers and parties. It's just that you just have to make yourself comfortable. And let me just give you some instructions before I release you for today. The deputy was nice enough to go ahead and give you the badges. I need you, while you're in this building, to wear those badges prominently on your clothing so you'll be easily recognized and identified as a member of this jury. And that way people are always cautious not to say anything in your presence, but court personnel will definitely be on their highest alert. And also, as I indicated earlier, on the back side of that badge is the office number. Obviously, things happen, emergencies happen. That way you can call the office and leave a message. The deputy, because we will do this routinely, has given you a pad and a writing instrument. I shouldn't say you can take notes today, but I'm just giving you some preliminary instructions. Now, those pads that you have in the pencils, if you could, just write your name on the cover sheet and then turn them face down in the jury when you leave for the day. They're going to be in there when you get back. Nobody's going to look at your notes on the day, but help. It's just that easier for managing that to leave them always in the jury room. If you, and I'm not saying you will, but if you do decide to take notes and you use that pad up, we will give you more pads. So don't worry about it. You can write as much as you want, write as little as you want. So we have a lot of pads to give you if you need to take notes during the course of the trial. And like I say, those badges, you will be taking those with you, and Jay will be giving you additional instructions on which interest you will be using throughout the course of the trial. You will be given the parking code to assist you in going in and out of the parking garage. And that changes, but we will update you on a regular basis when that changes. So you will be able to come and go out of the parking garage as necessary. I will give you hard times on which we will start each and every day. It'll be a soft time. I won't give you a soft time yet, but you will get an idea on when we'll be leaving, and so that you can have some normalcy in your life. The lawyers have indicated, and the case will take several weeks, and so just planning accordingly. We're letting out early enough today so that you can prepare yourself so you can be here Monday on, so you can contact your employer and let people know where you will be with us at the same time. You are the jury. That's it. I mean, so this is it right here. The selection process has completed. This is it. I have to count on each and every one of you to show up each and every day with an open mind, ready to listen to the evidence that comes from this witness stand and any physical evidence, and review any evidence that is introduced during the course of the trial. Let me give you these instructions because I'm going to send you home. My habit is to say for the evening, but it's going to be several evenings. So we're not going to get back together until Monday. I know today's Thursday. But because of some things that I just have to coordinate, we're going to come back together on Monday morning, and at that point in time, I anticipate starting the trial with the opening statements and then followed by the presentation of evidence. When I release you, and you've heard this already, but I got to say it again, do not discuss the case or allow anyone to discuss the case with you. This is a very critical process at this point in time. As I said, it's an honor system. You're not going to be sequestered. You're going to leave here each and every day, including today. And I won't see you until Monday morning, but do not discuss the case or allow anyone to discuss the case with you. Do not stand near anyone who may be discussing the case. Do not look at any media coverage pertaining to this case. Obviously, we all go out, we interact, and TVs are on in restaurants and businesses where we are. If the TV's on and it appears to be I'm gonna use the term a news story, but it could be something else, and you think they're saying something about the case, walk away from that TV screen. Do not look at it, do not read the teleprompter, don't listen to it, but don't get any information about this case. I need you to do the best you can. Once I release you for today, do not remain upon the floor, because I don't want you to interact with anyone at this point in time who you should not interact with. And I don't want you to hear anything or see anything you should not see. Do not read or look at any media coverage pertaining to this case. Do not go upon the internet and do any research whatsoever about this case. Do not blog about this case while it's ongoing. Do not send text messages, email messages, or receive email messages about this case while it's ongoing. Do not go by any location that may or may not have been made reference to when I read the indictment to which all of these charges Mrs. Sneiderman has entered the plea of not guilty. And as I indicated earlier, she is presumed innocent unless and until proven guilty in the court of law. And at the appropriate time, you will have the indictment out with you also with a proposed verdict form, but that is at the conclusion of the trial. You're more than welcome to bring something to snack in or eat with you any day, not just Monday, but every day if you wish. You can drink a beverage, a hot or cold beverage there in the jury box, but you can't eat in the jury box. You'll just have to leave anything that you want to eat there in the jury room. You will eat those, consume those items at the appropriate breaks. And I would say this every day, but throughout the course of the trial, do not consume any alcoholic beverages during lunch, or while the trial is going. Obviously, when you go home, if you do consume, because you're over your legal age, consume in moderation, because you cannot, and I don't want you to come to court the next day with a hangover. I can't say it any clearer than that. So if you do consume, because that's your lifestyle, just do it in moderation, at least during the course of this trial. Because obviously if you come to the building, I'm just generalizing, and if the bail is on detecting an alcoholic beverage upon your person or your breath, it's a different issue I got to deal with. So all I can do is stress that on the front end. The deputy will return to you your cell phones, iPhones, and iPad devices when we finish this presentation. And each day the deputy will collect the items up from you. You cannot have any cell phones, iPhones, iPads, any type of communication device during the jury room. And I know he was mentioning to me, he has quite a few, because some of you had 2 phones, which is okay. And I know you got to be in contact, if it's possible. Because you're gonna go home and have lunch break. I'm just asking, but if you got to bring all 3 of your phones, it's okay. But it just makes a lot for him to have to keep up with every day. If you could, if you have to bring one, could you only bring 1 phone, but you can bring as many as you wish. So I'm not limiting you, but I know that his box is full because of a lot of phones and but it just makes a lot for him to keep up with, which is okay, and we will accommodate you. If you got to have that kind of communication, but remember, they're not going to be with you during the course of the trial in the jury room. You're only going to be checking the messages during the extended breaks, okay? And at the end of the day. But you're going to get them back every day. But those bigger items, the iPads and the laptop computers, it becomes very bulky with the number of you, but this is a request. And if you do bring them in, which is wonderful, please put them in the off position. The lawyers and the parties and the litigants and the people who know what it is, they cannot talk or interact with you, in particular lawyers. But I don't ever want you to think they're being rude or discourteous, and don't draw anything from that. Because the reason I keep saying this is courtroom 5D and what time we're going to start, because you're going to have to remember. Because if you see them on the elevator, although they're going to the exact place you're going, and you turn to them and say, which courtroom is Judge Adams? They're not going to say a word to you. But I don't want you to draw anything from it, because that's why I'm telling you where you're coming back to on Monday, courtroom 5D, but don't draw any emphasis from that from the lawyers if they don't talk to you. Even if you see them over the weekend, you say, hey, how you doing, Mr. or Ms. Stone? They're not going to respond to you, because they're not going to communicate with you on any level. But I've told them that, they know that's the rule, but don't draw any emphasis from that, okay? They can't talk or interact with you outside of the presence of the court. We're going to reconvene on Monday morning, and I believe some of the school systems may be starting, the city of Decatur started this day, and I think some others may start on Monday, which is wonderful, which means more buses and automobiles are going to be on the street. I just say that to let you know, wherever you're coming from, at home or wherever, it doesn't matter to me, you're going to have to leave there enough time to park your car. And I know this sounds very basic, but if people weren't coming to court late, I wouldn't have to keep saying it. Park your car, come through the metal detector, ride the elevators, come up, and come through either this door or a different exit. We may have it set up, just depending on logistics, because you're going to exit through a different door today. But we will accommodate you. But I just need you to be in that jury room physically by 9 o'clock a.m. 9 o'clock a.m. on Monday. 9 o'clock a.m. on Monday. Any logistical questions, wonderful, hearing none. Any communication that you have to do with the court, you're gonna have to write it down, but no one is released. You are on this jury. Thank you very much for your patience. I thank you in advance. Have a wonderful weekend. I will see you on Monday morning, 9 o'clock a.m. Have a great weekend. Get some rest. All right? And you're gonna be exiting through a different exit, so it's okay. Just follow the instructions of the deputy. He's gonna give you your cell phone back. Leave your notepads there, turn them face down, continue to wear your badges, take all your possessions with you if you don't mind. You can carry your possessions with you. And you can just leave all those things there in the jury room. They'll be in the jury room. You come back on Monday. 9 o'clock a.m. on Monday. See you in 3 days. 9 o'clock on Monday, a.m. You can be early, but you can't be late. 4 days. You're correct. I'm thinking it's Friday. You're correct. Thank you. All right, lawyers and parties, you may be seated. All right, is there anything else for the record for the state?
Nothing from the state, Your Honor.
From the defense?
No, sir.
All right. Any other, let me just very quick, lawyers, would you approach this time, one last issue?
Welcome back to 11 Alive's coverage of the Sneiderman trial. So here we are. We are wrapping up things very rapidly on this Thursday afternoon. I'm Jeff Hullinger along with Bill McKinney, who is an attorney who has been providing our analysis today. So the judge said you are the jury. Opening statements are going to be Monday. The trial should take 3 weeks. It will all begin at 9 a.m. And Bill, let's break down this jury as we know it. 9 females, 6 males are on the jury. 2 Caucasians, 1 Hispanic, and 13 African Americans. Surprised by any of that?
I'm not really surprised. I think the prosecution is happy about having the females on the jury. I think that is a very good jury for a prosecution, particularly in this light of the circumstances of this case.
And the judge has been very active with his instructions to the jury and their responsibility and the expectation of them to the duration of what is at least projected on this Thursday to be 21 days of trial.
That's correct, and I think what you're going to see starting Monday, and each time they reconvene, he's going to be asking that jury basically, has anyone contacted you? Have you read anything? Have you seen anything? Just to make sure, again, because they're not sequestered, that they're not being influenced outside the courtroom.
We talked, and I'm looking at this total here. Let me say it one more time. 9 females, 6 males on the jury, 2 Caucasians, 1 Hispanic, and 13 African Americans. As we drifted into this day, would you have been surprised by this tally, or is this pretty much what you had expected?
We didn't hear the actual jury selection today. We only saw the actual panel going back and forth. But it's a good mix. It's almost 6 and 9. I mean, you're looking almost at a 6 and almost a half are male and half are female. I think it's a good representative of the community, and I think it's going to be a pretty fair trial. I really do.
She's looking at 13 felonies, and again, some of the issues that are going to be at the forefront. One of them is infidelity, which will be very high. There also is the belief that the issue of being stalked by someone from work, that's going to be a very central issue as well.
I think it will be, but as I said early on, the women normally, in my experience in trials, are harder on women than men are. Men are more forgiving, and the fact that you have infidelity, and again, we don't know the backgrounds of these women, but if these women come from a stable family, they have not been divorced, they haven't been separated, they love their husbands, there's no infidelity involved, they're going to be very, very hard, I think, on the defendant in this case.
All right, so what is going on right now? Are these final instructions?
Yes, you heard there was a motion made at the last minute about the sequestration of experts. I think they may be discussing that. There's been no objection to it. The judge's reserved decision on it. What they're talking about now is probably whether there's going to be PowerPoint, whether they need video, how opening statements are going to be made, and how long he's going to allow each side, whether it's going to be an hour, 2 hours on each side to make their opening statements. And then they probably are discussing a little bit about the witnesses, because each side, or I should say the prosecution that goes first, has to have the witnesses lined up. We can't wait for them. So they may be asking, how long do you expect opening statements? Well, maybe 2 or 3 hours. Well, okay, what are your witnesses? We have 4 witnesses. Okay, so they're trying to make sure they have enough witnesses to fill that day and then be ready the next day with another group of witnesses for the prosecution.
Do you anticipate any surprises next week?
The only surprise that I could see was this issue about experts. And I don't know at this point what the experts are going to add to this case unless there is a surprise we don't know about. Because this is basically, unless they're going to claim that she was in shock, she didn't know what she was saying, was delusional, upset. Other than that, I don't know what type of experts they are bringing in on this type of case.
So when we get to Monday and there are opening statements, the first day, what should we expect on the first day? Is it a lot of sort of sensing the other side, seeing how things are going to play out? Is that what a first day historically is about on these kinds of cases?
This is the first time that the jury is actually going to hear from the attorneys as to what the case is about. So normally what the prosecution is going to do is lay out their pattern and their theory of the case and how they believe. It's almost like a index to a book or a puzzle. They're going to give you the full picture, and as those pieces come in at the end, that puzzle is going to say guilty. And so what they're trying to do at this point is put their best foot forward, not make expectations too high. Don't say we're going to do this and this if they can't prove it. I think they're going to probably low-key it, be matter of the fact, factual, explain what they think each witness is going to tell them, and then they're going to sit down.
So again, 3 weeks is the projection as to how long this will last. Could it go shorter than that? Are there those kinds of scenarios, those cases? Though this would not seem to be one that would play out shorter. Longer has been certainly the case this week as opposed to shorter.
It largely depends on whether there's going to be objections and motions filed during the case. And as the evidence is coming in, there's always the opportunity for defense to file new motions. Even at the end, they can file new motions on the case. So you don't know, except the issue here really is whether she was credible in telling the truth. So I expect police officers, law enforcement officers, witnesses who heard her statements and written statements and her video. So other than that, I don't think it's going to go 3 weeks. That's my prediction is that it may go less than that.
If you were Andrea Sneiderman's attorney and part of her defense team, what would you try and coach her on as we approach Monday?
First, I would tell her that if she decides to testify, because obviously she does not have to testify, but the jury watches her at every moment when she walks in. So I would tell her from the moment she gets out of her car until she gets in the car to go home, you're pleasant, you smile, you dress appropriately, you don't have any mean faces or anything like that that would upset a juror, and just be pleasant.
Back to the courtroom.
Thank you very much for your indulgence. Thank you very much for your patience as we went through this process. Anything else for the state for the purpose of the record?
Nothing from the state, Your Honor.
Defense?
No, sir.
Lawyers, we will be in recess, Mr. Deputy, until 9 o'clock on Monday morning.
All right.
All right, that is it. 11 Alive's coverage now coming to an end, at least for this day. Tomorrow will be a dark day on this trial, and then Monday we'll begin the evidence portion. Bill McKinney has been our guest, a fine attorney who's been in the House giving his thoughts, observations, and musings on all that has transpired not only this week, but coming up next week. Some closing thoughts as we head toward the weekend?
Yeah, first, it was a pleasure working with you.
You're very kind, Bill.
Commenting on it. All I can say is I think they could not have picked a better jury for both sides. It sounds like they really have a lot of work to do and get ready for those opening statements. And I think the opening statements are going to tell us exactly how this is going to play out.
And one more time, we have 9 females, 6 males, 2 Caucasians, 1 Hispanic, 13 African Americans are on the jury. And again, Judge Adams said to this jury, you are the jury. And opening statements will be Monday. The trial will be 3 weeks. And that is it for now. We will have complete coverage coming up for you tonight on 11 Alive News at 6, then the 11 at 7 with Brenda Wood. Judge Hatchett will be with Brenda. I will be out here with attorney Jamila Hall. We'll talk about the day as it has turned out inside the courtroom. Then on the rundown on my ATL TV, WATL channel 36, that will be at 10 o'clock, and then at 11 o'clock, it is the news coming your way on 11 Alive. So until then, I'm Jeff Hullinger along with Bill Kenny. Have a great afternoon, everyone.